Kathy Watterson from RE/MAX. I've been promising that I'm going to have a meeting with my favorite estate attorney, Randy Armour. So we're going to sit here and chat, and I'm going to ask him some questions, and he's very knowledgeable. I've known him for, how long have I known you now, Randy?
Oh my goodness, you were a kid.
Yeah, I was
It's
a kid.
been-
That's right.
It's been like we were just figuring this out, maybe 35 years.
Yeah, I started at RE/MAX in 89.
89,
Yeah,
so 36
yeah,
years
yeah.
ago. I was there already.
Right, right.
Yeah, amazing.
Yeah. Well, thank you so much for coming today. I really appreciate it. You know, like a lot of people tell me, and personal people I know, it's uncomfortable to talk about trust because now you're thinking of dying, and who wants to die? Like, my joke is I'm living to 100. I don't want to die. So let's talk about how important it is for families to make sure they have a trust, how important it is, what it does. I'll ask questions along the way, and we'll go from there. So,
Okay, sure.
yeah, what's the importance of having a trust to not having a trust?
Well, first of all, let me give you a little background. And before I do that, I need to tell you, nothing I say today is to be taken as legal advice. We're just having a conversation about general estate planning principles. Don't take anything I say and go out and implement this. Talk to a legal professional. Every plan is going to be different.
Right.
So getting right into a trust is an entity that is created, and it serves a lot of purposes, has a lot of advantages. And for most of my clients, probably the biggest advantage of having a trust over, say, a will is that it's going to avoid probate. And so first of all, what is probate?
Right.
Probate is the legal process of transferring the assets of a deceased owner to whoever the beneficiaries are, whoever those assets are supposed to go to when a person dies. And those beneficiaries can be determined in different ways. Everybody has a plan, whether they know it or not. I'm talking about an estate plan. So you can do your planning through a will, a trust, or if you do nothing, California has a plan already in place for you.
Which is probate?
Which is the assets will go to typically your heirs at law, your closest blood relatives,
Okay.
or if you're married to your spouse, or if you're married with children, it might go partially to your spouse, partially to your children. There's a set of laws called the laws of intestacy that determine where your assets go. So you can come up with your own plan about where your assets are going to go. One way is to do that is to do a will. So if you have a will and your assets go to the beneficiaries when you die, it's going to take a lot of time and money going through the probate process before it can go to those beneficiaries.
So let me ask you something. If you go to probate without a will, so the state will determine who gets that. But if you have a will, does the state look at the will and say, okay, this is what they wanted, but now we have to go through the probate process?
Either way, it's the same process.
Okay.
It's the probate process the same whether you have a will or not. It's just
Okay.
ultimately who's going to end up with the assets would be determined by the will if you have one, and if not, by the laws. Those are the laws of intestacy. But it's the same process. And probate, just to give you an idea, probate in California, typically for a simple probate. So let's say there's one house, an investment account, a bank account, 2 adult children, right? Everything's going to go to those children if you don't have a will, because, a single person dying, the assets typically would go to their heirs at law, their closest blood relatives.
Right.
So the law already says it goes to those children. If you have a will that says, I leave everything to my children, it's the same exact plan. Either way, it's going to take about a year to a year and a half on average for a simple probate, like a case like that. And the cost is going to be in the tens of thousands of dollars, depending on the value of the asset. Say you have a house that's worth $1 million, and it doesn't matter if you have a loan or not. The cost is not determined by the equity, it's the fair market value.
Okay, that's good to
So
know.
this just a $1 million house,
Yeah.
you're probably looking at $25,000 to $30,000 if that's the only asset to be probated. And once again, a year to a year and a half in court before your children get those assets.
So that leads us to the next question, what the benefit of having the trust is, so you don't have to go through that.
Okay, when it comes to probate, there's a lot of reasons to have a trust. But the biggest advantage, as I said, for most of my clients is it's going to avoid that probate, which is a court process. And the reason is probate is only required when the owner of the assets dies. So we have a house titled in your name, and there's a lot of scenarios. Let's say it's just an individual, right? The surviving spouse or a single individual, unmarried, and they own the property in their name, right? So when they pass away, how do you get the property out of their name? That's what probate is. Okay. How do you get the title transferred from that deceased person to those children or those beneficiaries? And so if you establish a trust, so we set up the Kathy Watterson Trust, and it's an entity that can now own assets. So we transfer the property out of your name as an individual to your name still, but as trustee of the Kathy Watterson Trust. The trustee is the manager of the trust. Now you're the manager, but the trust is in a way now considered the legal owner of the property, right? So even if you pass away, there's no probate because probate is only required when the owner passes away, and the owner is now the trust, and the trust can't die. Okay. So very simply, that's how a trust avoids probate. Now the trust contains instructions just like a will. As far as what happens when you pass away, who do you want to get that house or those other assets? So the assets now can pass to those beneficiaries without that probate process. So you name somebody to replace you as the trustee or manager of the trust, and the trust gives them the authority now to just distribute the assets out of the trust to your beneficiaries. No court required, no probate. And in a lot of cases, this can be done very quickly and inexpensively. So that's one of the main advantages of a trust.
Okay. And is there any, when you, the property transfers to your children, do they have to pay taxes on that?
Yes and no. Typically, they don't have to pay taxes, no. When the property transfers to them, inheritances are not taxed like income. Okay. So there is a federal estate tax. So when somebody passes away, the value of their assets is determined. And if their estate exceeds, we'll call it the estate tax exemption amount, then the estate is taxed before the assets get distributed. But the beneficiaries are not taxed. So, and the estate would only be taxed, as I said, if it exceeds the federal estate tax exemption amount, which this year just went up to $13,990,000. And if you're married, essentially you double that. So almost $28 million before you have to start worrying about that. Now that may go down in 2026 to approximately, they're estimating $7 million per person, but I think that will change. We just don't know. But just people should keep that in the back of their minds if they think they're approaching those types of figures.
So, and that figure changes a lot, right? Not a lot, but it can change every year?
Well, it does. It's indexed for cost of living, CPI. But I won't get into the why it might go down in 2016. The current law will sunset. We'll go back to an old law which had a lower exemption with cost of living increases built in. So if nothing happens, it'll be around $7 million per person, but I don't think that's going to happen.
Got it. Okay. So, I mean, simply said, a trust is good to have for your family, so it's all spelled out for them. If you die, it's spelled out for them what you wanted and how everything's going to be divided. On top of that, they don't have to go through probate, which other people could show up during probate. Is that correct? And say that they might be entitled to something?
Well, that's actually usually not the issue.
Okay.
Because with the probate, so I used to do a lot of trust litigation, probate matters that I don't do anymore. I'm now more focused exclusively on the planning. But if you go down to the courthouse and go to the probate department, you can see all this litigation. It's actually pretty interesting to watch. But I tell people rarely is there going to be litigation if there's a probate matter when they have done no planning. And I'll explain why. Because the laws clearly state who the assets go to, right? Okay. Usually the litigation that occurs when family members are fighting each other in court, it's because the parents did some type of planning. They just didn't do it correctly. Either they tried to do it themselves or they used somebody that wasn't qualified, and either the documents are not clear or there's going to be a lot of reasons why they're now fighting, claims of undue influence, incapacity. But usually it's because they did do something, they just didn't do it correctly.
A will is also good for couples that have young children, because part of the trust, and a will, correct me if I'm wrong, can stipulate who's in charge. I remember when we did it when our kids were little, like, okay, who's in charge of the children, who's going to raise them, who's going to be in charge of, our estate and the money, and that's very important to do.
Estate planning encompasses a lot, and two main categories would be, one, what happens during your lifetime. So really what we're looking at is things that people don't want to think about, right? Incapacity, death.
Right.
But it's lifetime planning as well, because what happens if you become incapacitated?
Right.
What happens if you have minor children, right? What happens if you have medical issues that arise and you're not able to make those decisions? All of this is part of estate planning. So that first part, lifetime planning, encompasses a trust, because another difference between a trust and a will is a will only becomes effective during your lifetime. Okay? So you've probably heard the term last will and testament, right? Mm-hmm. That testament part is Latin, meaning rising or becoming effective upon death. So a will is a testamentary document. During your life, it means nothing, so it doesn't help manage your assets if something happens to you. A trust, you've probably heard the term living trust, or in Latin, it's inter vivos trust.
Yes.
It also allows you to set up a plan where you are choosing who is going to have the authority to manage your assets during your lifetime, as well as determining who is going to distribute those assets to the beneficiaries according to your instructions when you die. So there's two parts of the planning, which once again, planning for assets, management of assets, people don't realize. So there's a statistic that I've used many years ago. I just looked it up recently. They're looking at the same numbers. So for people over 65 now, and unfortunately I belong to that group, no, you can't be. But anyways, so 70% of us, unfortunately, are going to need some type of long-term care before we pass away. And there's a whole spectrum.
Right.
But so we have to plan for that, right? What if we can't pay our bills? Who's going to do that for us? We want our house to get foreclosed, so we can set this up so you determine who's going to have the authority to step in to manage things for you, or raise your kids if you have minors, or all of those issues we look at for lifetime planning. And then, of course, the other part is when you pass away. We want to avoid probate. We want to make sure the assets go where you want, right? With as little cost and difficulty and time as possible.
And yes, we want our children, I can speak, my children to get the money, not have to pay the state and go through probate. And I want to make it simple for them, because if any of you have had somebody has passed away, it's a lot of work. Even going through a trust and being an executor, it is a lot of work. But at least it's spelled out for you.
Yeah, things don't happen by themselves.
Right.
So I tell people, if you're going to set up a trust, the most important thing to consider is who you appoint as what we call the successor trustee. So the trustees are the managers, which typically are the people who establish the trust, but if they can't manage the assets, the successor trustees replace them, will step in. That is crucial. And I have actually told people, based on family circumstances and the fact they didn't have anybody they trusted, that maybe a trust wasn't the best thing for them. Trust is a good name for this thing. You're putting this person in charge of all of your assets and leaving them instructions to follow, but there's no court now overseeing this to make sure that they're doing what you said. There are laws that hold them responsible, that say they have to, but if they don't, then that leaves your beneficiaries now having to sue them. And so it's very important, if you're going to set up a trust, that you think hard about who you're going to appoint. Now, there's options that we will always discuss with our clients. You can name individuals. You can name have two or more individuals acting together. You can have individual, there are what we call private professional fiduciaries out there who could do this for you. And there are institutional corporate trustees. So depending on the situation, we will go over those, and maybe based on what you tell me, I'll advise you as to which options I think would be best for you.
Okay. And then I know I wanted to share, so people know this too, we got a trust with you, gosh, I think my trust was 1991, I think. And our kids were little, so we had it all set up, who would take care of them, who would be in charge of the money and distribute it. And there's probably been 4 times since then, because they are adults with children now, where we've come back to see you and changed that up to the point where now they can be the trustees and, change everything up. And it's good, if you do have a trust, to have it viewed and looked at to make sure it's up to date, it's what you want, if there's any changes in law. I mean, that's what you're for, Randy, right?
Yeah, well, absolutely. That's one of I think the biggest mistakes people make is they get this set up, they put it away, they forget about it. 20 years go by, the circumstances are completely different by the time something happens to them. And these are not their wishes now, but that's what it said because they never updated it. So most 99.9% of the trusts I've done over the last almost 30 years, and that I was thinking about it the other day. It's somewhere between probably 7,000 and 8,000 estate plans I've done. So, over those years, I have all these trusts out there that are 30 years old.
Right.
And I don't see a lot of people come back and update them. And then when they die, I know that this trust does not now reflect their wishes.
Right.
But so it's really important to for you to review your own documents, right?
Right.
And then there are also, this doesn't happen often, but changes in the law. So prior to 2010, the estate tax laws were very different. Most trusts for couples were set up as what we call A-B trusts, where the trust would split into 2 trusts for tax advantages, but the laws have changed. Now there's actually tax disadvantages to having those types of trusts, but there's thousands and thousands of those old trusts out there that have never been updated.
I don't have an AB trust, do I?
You do not.
Okay. There's a lot of information. Trust me, a lot of this still goes over my head, but I trust you with my trust. So this is why I like to talk to you and have my trust reviewed. Also, I want to bring up a very important point that I've seen happen over the years of selling homes, where people, typically you have to take your house out of a trust when you do a refi, and then after you do a refi, because a lot of lenders will not let you get a loan in a trust. So what we do is we take it out of the trust, put it in the couple's name or whoever individual is getting the loan, and then put it back in the trust after. I have seen over the years people forget to put it back in the trust, and I have seen people end up, they've died and it didn't get back in the trust. And we don't need to get into all of that. I know there's a whole way that if it was intended to, then there's a what's it called, the Hegstep petition.
1993 case, which most people do not have that language in their trust documents still. Okay. So yes, I've done many probates for estates for people that died that did have a trust, which was intended to avoid probate, but the assets need to be owned by the trust.
Right.
And if they're not, if you don't have this other specific language in the trust or in a separate document, it's not part of the trust. It requires probate. So that's interesting when I meet with families and they come to see me after their parents died and they bring the trust. I explain it to them. Then I pull the title to the house and I realize it's not titled correctly, either because they never put it in the trust or they sold that house, purchased a new house, didn't put it in the trust, they refinanced, it came out of it, whatever the case is. And then I look for this language in the trust that I can use to prove that house belongs to it. It's not there. So now we have to go through that entire probate process to get the house into the trust, which was designed to avoid probate, right?
Right.
So unfortunately, I've done that a lot over the years. That's one of the, reasons. I can give you a million reasons why you should not be doing these plans yourself, why you should have a professional who knows about that and can put that language in the trust for you.
Okay, we're going to wrap up soon. Is there anything else you thought of that you wanted to talk about that I missed?
I could talk for days. I'm very passionate about estate plans.
Randy, you're very passionate. 2 things I just want to close with. 3 things. 1, make sure your house is in the trust if it was supposed to be and you did a refi and not sure. Or if you did a trust and you just need to double check, which I do every couple of years, have my title gal. You can call me if you need help. make sure my properties are in a trust, just to be sure. Number two, call Randy, have a consultation. He'll talk with you. He's very straightforward, very knowledgeable.
I've grown up in Santa Clarita Valley. My parents moved here in 1965, right? So I've been a member of this community, and I offer something. I don't think there's any other attorney out there doing it. I offer for the first consultation, when somebody comes to meet me, I offer a 2-hour complimentary consultation.
That's great.
And because I need to gather so much information before I can advise you what I think you need to do. And during that 2 hours, you may decide you don't want to work with me. I may decide I don't want to work with you. But normally, you know, you can see how thorough a job we do, right? Up front, before you decide to hire me. So after that, and I will tell you when we're done exactly what it would cost. People walk in and say, how much does an estate plan cost? I have no idea. It's like somebody coming into the office here and asking you, how much does a house cost, right? But by the end of that 2 hours, you will know exactly what I am advising you to do and exactly how much it would cost before you commit a penny. And if you decide not to hire me, it hasn't cost you a thing. You're going to get a lot of education during that 2 hours, right?
Awesome. That's awesome, Randy. And your cost obviously goes depending on how much property they have, how much money they have, those kind of things?
Not really.
So it's not a bigger...
So, you know, somebody who has a $10 million property, the plan probably will be the same plan if, you know, they have adult children, whatever, as somebody who has a property that's worth $500,000.
Right. I don't mean I don't mean the price of the property, meaning like if someone just has one home and some adult children based on somebody else that might have 10 investment properties.
Right. So the cost of the actual documents, and there are several documents we haven't had time to go over that are included in the plan, might be the same. But yes, each additional property then has to be transferred into the trust. So there's obviously a cost to do all the deeds and the research to do that. Yeah, absolutely.
All right. So, Randy, thank you. I know this is kind of a first for both of us, and I appreciate your time. I highly recommend you. And I just want to say thank you.
Well, thank you for having me. It was great to see you again.
You're welcome.
And I'm sure we'll be working together in the future.
Yes, and Randy's great when I have questions. And please take advantage of his 2-hour complimentary session with him because you'll learn a lot for sure. And reach out. We'll get you his information. And have a great day.